Welcome back to Morning View. I'm Marianne Fogelson. Our topic today is patent legislation. Get your calls in at 1-800-5000-NET, or of course you can send us a fax, 202-544-4132, or if you are so inclined, send us an email. morning@fcref.org is our address. Our guest today is Phyllis Schlafly. You all know who she is. She's from the Eagle Forum, and she has been a leader on this patent rights, the two pieces of legislation and the problems that exist surrounding this legislation. Good morning.
Good
Phyllis,
morning,
thank
Marianne.
you for joining us. Why don't we start off with the Constitution? What does the U.S. Constitution say about patent rights?
The Constitution is unique in regard to patent rights. It gives the inventor the property right in his own invention for a limited number of years. And the Founding Fathers thought this was so important, they put it in even before they put in freedom of speech and religion. It's what makes our country different. It's a different system from every other country in the world. In other countries, you had to be a pal of the king or have some vested interest behind you. But in America, it's a completely democratic right. You invent your new mousetrap, you make your application for a patent, it's all kept secret until you get your patent, and then you have your property right for about 17 years, and then it goes public. But the foreigners don't like this because they want to steal from us. But America has more than 90% of the inventions of the world. The others have very few. And I think the reason for this is our unique system of patent rights, along, of course, with our private enterprise system. And so what we have is a bill racing through Congress to diminish the traditional constitutional rights of the inventors in order to harmonize us with other countries. And there's no reason why we should diminish our rights in order to accommodate the other countries that basically want to steal from us.
Phyllis, who's interested in having this legislation move through Congress? As a reporter covering Congress and as an editor at the Washington Times, we were always taught to sort of follow the money and follow the influence. Who's behind this move?
Well, first the Japanese and then the multinationals. And you can trace the language of this bill straight to a deal that was made between then Secretary of Commerce Ron Brown and the Japanese ambassador. It was in September of 1993 that the Japanese Patent Office just announced that our patent system was unsatisfactory, and they demanded that it be changed. And then a year later, in '94, Ron Brown issued a press release saying that they would change it. And there are two specific ways they wanted it changed. One is they want all the details of inventions published 18 months after the application is filed. That means before you get the patent, before you know if you're going to get a patent, or before you know how broad the patent would be.
So before the idea, this original idea, this unique new product or a unique new system or whatever it is that you've put your life into that is unique and might have a marketable value.
Yeah, you may have worked 40 years on it.
Right, before that's even registered in the patent office, other people would be able to look at your research, the methodology, all the things you put into it, before you could even get a patent and before you could even bring it to the marketplace. Is that correct?
That's correct. And because it's not until you get the patent that you know what your rights are. And you may never get it. And in which case you'd like to keep it secret and keep working on it until you develop it well.
Now, by other people, is that only American citizens, or are we talking about foreigners as well who can look into these patent applications?
Oh yes, the foreigners would be able to see it. It would be published. That means open to the public. Then the other thing that the Japanese demanded was to open up our re-examination process. Now, under the present system, once you get your patent, it's not opened up again or re-examined unless somebody can come in with documentary proof that something was published about your patent before you made your application. Now, what they want to do is loosen all this up, open it up, so the lawyers for the foreign and domestic corporations can come in and make the poor inventor fight his battle all over again. That's what it is.
We talked about in the opening, Phyllis, that this is really not so much an ideological or even partisan disagreement. It's sort of a big guy, little guy thing where you have a lot of inventors, many of whom don't know each other, many of whom are not aligned in political organizations. They don't have grassroots operations. There's no...
Or big high-priced lobbyists.
Oh, up against, I mean, the small inventors who are poorly organized, politically speaking, against large corporations who are very well organized and have very well-heeled lobbyists operating here and in other foreign capitals. Yet it intuitively seems essentially Republican small r, not big R, but small r, that this idea of maintaining the patent system as it is would be fought for by a lot of people, Republican and Democrat. Yet I haven't heard anything about this in Congress at all. Why Why no debate? Why no public discussion of this
Well,
so far?
there's nothing in the media. The only media that has covered it really is the Michael Reagan show. Outside of that, there is practically nothing. Now, when they debated it in Congress, if you're a C-SPAN junkie, which a lot of people are, they debated it for 2 days. So that was 7 or 8 hours of debate, and it was intensely interesting. And you listen to the arguments of the advocates, and the principal ones who spoke were the sponsor, Howard Coble, a Republican, and Barney Frank, Democrat. They don't have any real arguments. Their argument is we want to harmonize, we want to get along with other countries. And my answer to that is, if we're going to harmonize, we should harmonize on the basis of the American system, which has been eminently successful, and not on the basis of the Japanese system, which doesn't produce any inventions at all.
Why harmonize at all? I don't understand, other than the Japanese insisting to the Commerce Department that we change our patent system, why would any American citizen want to take away a constitutional right like this that would protect American citizens? I mean, this really shouldn't be a political issue. Why would Barney Frank or any legislator for that matter want to change a system that is so good the way it is?
Well, the multinationals are for it. And they have a different worldview from the rest of us. Their worldview is they want to go after their world markets, and that is their primary value. And they don't care about the rights of the individual inventor. And beyond that, the multinationals don't want innovation and creativity unless they control it. In other words, if you're a big corporation with a big market share, you don't want some guy in his garage inventing a better product that's going to cut into your market share.
Which, of course, is the essence of the American dream for many, many inventors. I mean, that's the big goal. A lot of the most innovative products in this country have come from people who work for large corporations, were sick of the bureaucracy, and got out by themselves, formed a small company. Almost the entire computer revolution were driven exactly by people like that, who had an idea, who had the skills, but were tired of the corporate bureaucracy, the multinational bureaucracy, went out on their own and created things that benefit all of us.
Well, and most of the world's great inventions were invented by lone inventors. You look at Thomas Edison, gave us the electric light. You look at Westinghouse. You look at John Deere. You look at the International Harvester. You look at all these great companies, Xerox, Dow, all the rest of them. They started with one guy and one invention who had his property right in his invention until he was able to develop it fully, gather the capital, and build a business. And this property right of the inventor in his own invention is what is unique about the American system. And if you make him publish it so that everybody can see it, then the people with the big resources can come in and beat him to the market.
Very good. Please stay with us. Our discussion will continue about patent law and patent legislation before Congress after we take a check on the nation's weather and listen to these commercial messages.
Thanks for joining us on Morning View. I'm Marianne Fogelson here with Major Garrett and Phyllis Schlafly of Eagle Forum. We are talking about patent legislation and your rights under the Constitution and maybe your rights being eroded under this legislation. Let's go to Ralph in Florida, your first-time caller. Good morning, and thanks for calling in.
Good morning. Ms. Schlafly?
Good morning.
Fight the fight. I have a patent. I'm a hydraulic engineer. I come up with a unique idea. I got a patent in '89. The company I worked for before fought me all the way on this. I wound up with $250,000 of my own money in it before I knew I could get a patent. I got it, and now I deal with all the major companies, or a lot of them in the country, and under this system that they're trying to bring in, that wouldn't even be possible.
Thank you very much, Ralph.
That's right. The big companies can go in and re-examine it and open it up and make him fight his battle all over again. That's what re-examination means.
And he probably would not have been able to find the financial resources to fight that battle a second time.
Right.
That's right.
I mean, probably, I understand, if I understand you correctly, Ralph, it was probably hard to fight it the first time, but he fought it with the anticipation of being able to do what he's doing now, which negotiate with big companies on his terms with the patent that he now has.
Sure, a lot of the big companies are trying to steal the ideas of individual inventors all the time. They have a very different interest. Now, this patent bill that's racing through Congress is very much written and supported by the multinationals, and you can see their telltale marks because in it they have a provision that it will set up the patent office as a new corporation, and it must have people on it who have experience and achievement in corporate management and finance. Now, what does that tell you? It tells you that the big corporations are going to control it and the little guy can be walked on.
What, you know, when you talk about re-examination and the big companies coming in and looking in on this and on our caller's patent, don't they need a good reason? Is there any kind of process set up to avoid abuses of this re-examination process?
Well, the present system is perfectly all right, and that is you can't open it up for re-examination unless they can come in, for example, with an article in Scientific American or a respectable professional journal that describes your invention before you applied for it. Now, in the absence of that kind of documentary evidence, you can't open it up for re-examination. But they want it wide open. This is one of the major things the Japanese demanded. The corporations with their big lawyers would like that. Now, when this bill went through Congress, I told you they debated it for 2 days, they did add an amendment by Marcy Kaptur.
Democrat from Ohio.
Right. And she was very eloquent in talking on this, and they deleted the section on re-examination and also made a modification about this early publication. But now Orrin Hatch has introduced the bill in its original form in the Senate. He is the chief sponsor. And when it went through the Judiciary Committee a couple of weeks ago, they did add an amendment which makes some changes. It's not exactly like the Kaptur Amendment, and it doesn't do anything to help the re-examination problem. But there's enormous pressure to push this through. It's a real stealth bill. I mean, what have you read about it in the local newspaper?
Read nothing at all about it. Phyllis, with your indulgence, let's bring James from Florida into our conversation. Good morning, James, and thanks so much for joining us.
Yes, I was just wondering, if this is in the Constitution, wouldn't it require a constitutional amendment to change it?
No, it wouldn't, because they would say you're not taking away the rights, you're just making some regulatory changes. That is the way they would argue it. And we don't look for constitutional amendments to protect our rights. So just go after your congressman. Tell them to vote no on Senate Bill 507.
Phyllis, you've identified the sponsors: Howard Coble, Republican from North Carolina; Barney Frank, Democrat from Massachusetts on the House; Orrin Hatch is the key sponsor on the Senate side, Republican from Utah, chairman of the very powerful Judiciary Committee. Who are the legislators who are fighting against this? And if there are folks out there who want to contact them or contact their congressman to talk to the people who are fighting your battle, essentially, the battle of the small inventor, who are they?
Well, in the House, those who are fighting the battle were, first of all, Dana Rohrabacher, a Republican of California, and then Marcy Kaptur, a Democrat of Ohio, whose amendment did pass. Other good guys were people like Duncan Hunter, Tom Campbell, who comes from Silicon Valley. They were very eloquent, Michael Forbes of New York. But it'll, of course, come back to the House after the conference committee. Now, in the Senate, the only senator who has really said anything in print is Senator Kit Bond of Missouri, and he has issued a very fine Dear Colleague letter setting forth the problems with it. And you want to urge him to be out in front on this and fight it. And when it went through the Judiciary Committee, Fred Thompson was the only one who voted no.
How about grassroots organizations? What kind of support are you getting out in the grassroots?
Well, because there's no publicity on it, it's really very hard. Of course, you need to subscribe to the Phyllis Schlafly report, and then you will have the whole story on it.
One of the things that often happens in Washington in a matter like this, where there is a stealth bill, something will happen in the House, it will not happen in the Senate, and then the House members and the Senate members, a very select group, will get together and hammer out what is called a conference report, which is a harmonization of the two competing pieces of legislation. And I understand your anxiety is that in the conference committee, Marcy Kaptur won't be there, or no representatives of the folks who are fighting this battle on behalf of the small inventors will even get in the room. And if they're not in the room, well, you can conclude, ladies and gentlemen, what's going to happen.
Right.
You're absolutely right. The conference committee would be made up of the judiciary committees of both houses, and all those people are for it. They were all signed up for it, and the ones who've opposed it are not on it. Now, the small business committee, for example, the House Small Business Committee under Congressman Jim Talent held a hearing opposing it. Roscoe Bartlett, who is himself an inventor, has about a dozen patents, is against it, but none of these people is on the Judiciary Committee. So their whole game plan was to send it to conference, fix it all up, and rush it through.
And it doesn't help that the chairman of the Senate Judiciary Committee is the chief sponsor of the bill in the Senate.
It is a real sellout. I think this is the most important bill in the present Congress. And it can do such damage to the future of our country by taking away the individual right of inventor. And that is what is the cause of all these wonderful inventions that we have, and we need to preserve that right.
All right, let's go back to the phones. Jim in South Carolina, good morning, and thanks for calling in.
Good morning, gang. Great show as usual. Good morning to everybody. I'd like to make a comment, and this is very important. All the viewers of NET need to be concerned about this legislation, whether they have patents or not, because 80% of the jobs in this country are created by small businesses, and these small businesses exist only because of our patent laws, because this is the only way they can fight the big guys. They don't have the money. The patent monopoly is the only thing that permits them to stay in business, and they're creating the jobs. And when we get rid of this, we're going to continue to ship the jobs out of this country.
Yes.
Well, he's absolutely right. I agree just 100% with that. And this bill is an attack on small business. It is a fight between the big multinationals and the small business.
Phyllis, what kind of remedy would a small business owner or an inventor have if this legislation passes and, in fact, their ideas are stolen?
He can file a lawsuit.
But that's just about it, and that
So in
costs
addition
more
to all the
money.
other costs that a small business person has to endure, taxes, rent, regulatory
regulations.
regimes, all that, then they would have to add on hiring a small business attorney to go fight this in court. And of course, who would they be fighting against? Deep-pocket multinational corporations or large corporations in this country who have plenty of money, plenty of attorneys, and could probably exhaust them in the civil court process.
That's right. That's absolutely right. And I think we also ought to realize the real importance of this particular right that the Constitution gave to individuals in America. It's different from all the rest of the world. No other country has a system like ours, and we have all the inventions. Now, that's not because American genes are better than the genes of people in other lands. It's because we have a system that inspires that guy to work in his bicycle shop for 25 years to invent the airplane and whatever.
And many other things. We'll be back in just a moment. Please stay tuned for another NET News Brief right after this.
Thanks for the update, Donna. Now back to the phones. George in Florida, good morning, and thanks for calling in.
Good morning. I have a comment. Major, you're doing a wonderful job. I think you're a great guy. And Marianne, you keep smiling no matter, you make them mad, but you're doing something right. So, and Mrs. Schlafly, I think you're a wonderful person. God bless you. We need more and more people like you up there in Washington. My comment is that I work for a big company down here in Florida, and before I was hired, I was made to sign a piece of paper that if I invented anything, it was theirs.
Wow.
I did.
Yes, well, that's very typical. Of course, when the patent is issued, it would be issued to the individual, but then you have signed over or assigned your rights. And of course, if they are financing you and hiring you to work on that particular project, that's okay. Now, sometimes the corporations go after people who didn't sign the paper, and they use their resources to steal it from him anyway.
How long of a process is it right now for somebody who has an invention, wants to get a patent, files for the patent rights? From start to finish, how long does it take, and what is the process? What kind of protections do we have right now?
Well, the average time is around 20 months or a little under 2 years. Of course, it's all secret during that period of time. And this is the bone of contention in this bill. The other people want to make it public so other people can see what you're working on and maybe work on it themselves. And you don't know during that period of time whether you're going to get the patent or not. And so to make you sign, to have a law saying that it's going to be made public 18 months after you apply is just so grievously unfair.
Phyllis, we have an email from Dick Dodge. He writes to say, "It seems to me the political supporters of the patent modifications are the very ones who would turn this country into world socialism, where free enterprise becomes controlled and owned by the state." Your reaction?
Well, there's a lot of that. You listen to their lingo, they're all talking about a global patent system, and there are global markets, and we have to be in the world markets. This is their lingo, this is the way they talk.
All this sort of at the altar of a global marketplace that's integrated but no unique members, you know,
Right.
with unique laws because they trouble and bother other countries, makes it more difficult for them.
The big guys like uniformity, and that's why...
And stability.
Yes.
And predictability.
Right. Now, let me point out, in the copyright law, about a year or two ago, we did have an international agreement whereby, for the first time, foreign countries will respect American copyrights. However, this patent bill doesn't do that for patents. There's nothing in this bill that gives American inventors any rights in foreign lands.
Well,
they can still steal them just as much as ever.
A tactic of the left that is very successful sometimes is once a law is passed, what the left will do is find somebody to file a lawsuit instantly and move for an injunction by the courts to get the law placed on hold for the time being until they can work up the public debate or change things. Do you anticipate that this battle will take place? Maybe somebody, an inventor, will file a lawsuit, do the same, pull the same tactic to try and stall implementation of this law should it pass?
No, I don't know who would have any faith that the courts would make the right decision. They make the wrong decision all the time. The people you have to go after are your senators and your congressmen,
right,
and keep them selling out our country with this bill. It has nothing good to recommend it. Now, they've tried to amend it to make some changes, but there's no way to amend it to be a good bill because it's bad and a sellout in every section.
Your position is leave it the way it is. It's worked fine for all these years. Why change it?
Why change it? And you know, of course, the Clinton administration is pushing very hard for this bill, and the patent commissioner, whose name is Lehman, has been very ugly about this. He said the people who are attacking this bill are in the Timothy McVeigh category. Now, how ugly can you be? It was an outrageous statement, and that's the way they're trying to bluff this thing through when nobody knows about it except the people who read the Phyllis Schlafly report and listen to NET.
Okay, back to the phones. John in Florida, good morning, and thank you for calling in.
Yes, good morning. Keep up the good work. Sounds like they're playing the terrorist card when they went out of the race card. But I have to tell you something. If you look at the Communist Manifesto, it clearly states in their top 10 goals no more property rights, and they're doing this with the after-death tax and the not having your property rights to your inventions is just another way of going along with the New World Order. You know, one collective, which is communism, Marxism idea. Thank you.
Well, private property is at the essence of this. And what our Constitution did, and what our patent law has always done, is to give the inventor the private property right in his invention for a limited number of years. And after that, it goes public. And this is why America has the greatest standard of living in the world. This is why all these wonderful inventions have made this such a nice place to live. You realize that when America was founded, men tilled the soil the same way they did in biblical days. But it's after the Constitution and the way we went to freedom and private property that all these inventions flowed from that. And now we're the breadbasket of the world.
And the model of the world, economically speaking. Phyllis, let's invite Jim from Georgia to our conversation. Good morning, Jim, and thanks so much for calling.
Hi, Phyllis. You're one of the most admired Americans, at least down here in South Georgia, that I know of. My real question is, how does this ever get scheduled when Newt Gingrich, you know it can't be scheduled without his approval. They can't debate affirmative action. They can't debate this or that. But legislation like this gets scheduled. Is he being bought off? You know he's got veto power over what is scheduled in the House.
Well, that's a very good question, and this Congress that we worked so hard to elect hasn't done anything so far this year except raise the taxes on our airline tickets, and yet this gets scheduled. What's the rush? Where does it come from? And all I can tell you is it's got some powerful, high-priced lobbyists behind it who have been telling their story for a couple of years, and the congressmen need to hear from you all out there in the grassroots.
Are we to assume then that the Republican leadership supports these two bills?
They haven't said anything specifically. If you're asking about Gingrich and Lott and Army, I don't know of anything on the record that they have said.
Probably
However,
because they haven't been asked, because no one's writing about this.
Right. However, obviously they did schedule in the House,
That's
and
right.
you'd think some other more important things should be scheduled, but they scheduled this for a vote, and it went right on through, and it was planned to go through without any amendment, and it just took hours of debate to get some changes made.
Let's get back to the phones and grab our last call for the day, or at least for this segment. Nancy in New York, good morning, and thanks for calling in.
Thank you for being there. I probably have called maybe 15 times on different shows, but this will probably be my most important opinion, and if this bill passes, I probably will not participate in the forum of discussion. This bill will take away what I consider my 11th Bill of Rights, and I don't care to participate in world government on the same level as Japan, and that's what they want. They want this bill to allow the same autonomy that the big companies have in Japan to be the same in America. This is like the underpinning of my freedom. I just can't believe that my officials would think the American public is so stupid.
Well, they were trying to rush it through without anybody knowing about it. That's perfectly true. And I agree. I think this is the most important bill in the current Congress. It's absolutely vital to the future of our country, to our freedom, to our jobs, to constitutional integrity, to the whole system of wonderful prosperity that we have had in America.
Phyllis Schlafly, that'll be the last word. Thank you so much for coming in, talk about this very important piece of legislation. In a moment, why finding out the whole story may be harder than you think. Stay tuned for the Daily Outrage. It's coming up right after this.